debunking the latest Republican talking point on impeachment. New damning information is coming out all the time about the Trump-Ukraine scandal at the center of the impeachment investigation. Republicans have field tested a dozen different arguments in an attempt to defend the president at all costs. But each one has been flimsier or weirder than the last. And their latest attempted defense is no exception. During the first public impeachment hearing featuring Ambassador Bill Taylor and Assistant Deputy Secretary George Kent, Republicans complained that neither of the officials were firsthand witnesses to the events under scrutiny.
Officials' alarm at the president's actions was typically based on second-hand, third-hand, and even fourth-hand rumors and innuendo.
We got 6 people having 4 conversations in one sentence, and you just told me this is where you got your clear understanding.
We're not in a court, gentlemen, and if we were, the Sixth Amendment would apply, and so would rules on hearsay and opinion, and most of your 2 testimonies would not be admissible whatsoever.
Well, so here's the thing. Republicans are only telling half of the story. First-hand witnesses, the people who have met Trump or worked directly with him and were part of the important conversations on this subject, aren't being allowed to testify. The White House is stopping them from doing so. Former federal prosecutor and MSNBC legal analyst Glenn Kirshner argues every single time a Republican complains of hearsay, secondhand information being introduced at the impeachment hearings, that statement should be viewed as powerful proof that Trump is obstructing the hearing by prohibiting the witnesses with firsthand info from testifying. There are certainly witnesses who have more firsthand knowledge than Taylor and Kent, but many of the witnesses the Democrats want to call, such as acting White House Chief of Staff Mick Mulvaney and acting Office of Management and Budget Director Russell Vought and former National Security Advisor John Bolton, have refused to come on White House orders or are being blocked outright from testifying by the Trump administration. Now, of particular interest, John Bolton's lawyer says his client has personal knowledge of relevant meetings and conversations that have not yet been discussed in testimonies thus far, all of which are being held up by the White House. Here's House Speaker Nancy Pelosi.
We are not here to be manipulated by the obstruction of justice of the administration. On the one hand, they say that it is secondhand. On the other hand, they obstruct all of the people who they would consider to have firsthand knowledge from testifying.
At least one Republican member of Congress believes officials like Mulvaney should testify. Republican Congressman Francis Rooney of Florida, who has not yet ruled out supporting impeachment, told CNN that he thinks Mulvaney should appear before the impeachment committee, saying, quote, "I think everyone should come to testify." And breaking tonight, one critical official is expected to defy the White House and testify in the impeachment investigation. The Washington Post is reporting that Mark Sandy, a longtime career employee at the White House Office of Management and Budget, is expected to break ranks and testify Saturday in the House Democrats' impeachment inquiry, potentially filling in important details on the holdup of military aid to Ukraine. Sandy would be the first OMB employee to testify in the inquiry. Mark Sandy could provide insight into the process by which almost $400 million in military and security aid to Ukraine was held up over the summer. The Post reports that Mark Sandy was among the career staffers who raised questions about the holdup on the aid. And Speaker Pelosi kicked her rhetoric up a notch today, using the word bribery to describe Trump's actions toward Ukraine, going further than she ever has before.
The devastating testimony corroborated evidence of bribery uncovered in the inquiry, and that the president abused power and violated his oath by threatening to withhold military aid and a White House meeting in exchange for an investigation into his political rival. The bribe is to grant or withhold military assistance in return for a public statement of a fake investigation into the elections. So that's bribery.
That's bribery. Pelosi's remarks come just days after House Intelligence Committee Chairman Adam Schiff told NPR that Trump's potentially impeachable offenses include bribery. And notably, the U.S. Constitution explicitly names 2 impeachable offenses, treason and bribery. And as the New York Times writes, Pelosi's use of the word bribery is significant because it suggested that Democrats are increasingly working to put a name to the president's alleged wrongdoing and moving toward a more specific set of charges that could be codified in articles of impeachment in the coming weeks. Leading off our discussion tonight, our Democratic Congressman David Cicilline of Rhode Island. He's a member of the House Judiciary Committee and the House Foreign Affairs Committee. Joyce Vance, former U.S. Attorney for the Northern District of Alabama, and she's an MSNBC legal analyst. And Neera Tanden, former senior advisor to President Obama and Hillary Clinton, and she's president and CEO of the Center for American Progress. Thank you all for being here. And Congressman, I want to go to you on this first. The White House's argument, or the Republicans' argument on their behalf, has been that all of the witnesses who've come forward thus far are secondhand. They hold secondhand information. They didn't talk to Donald Trump directly. They didn't participate in the events they're testifying about directly. And yet they're holding up all of the direct participants and not letting them testify. Does it surprise you that the response of the House committee has not been to simply subpoena and order the direct participants to testify? Or do you think it's smarter to say they're not testifying just becomes another article of impeachment?
Well, first of all, they're wrong about the absence of direct evidence. We have, of course, the president's own admission of wrongdoing. We have the telephone transcript in the president's own words. We have the whistleblower report that details the elaborate scheme. All of that has been corroborated by witnesses. We're going to hear additional witnesses who have direct knowledge of conversations. Lieutenant Colonel Vindman, who listened in on the call, a number of people who wrote text messages and emails. So there's the overwhelming evidence. The facts really uncontroverted. And I think we're making the right decision. Look, we've asked witnesses to appear. We've subpoenaed witnesses. But we are not going to be dragged into a protracted period of litigation so the president can drag this out. We've put the witnesses on notice. If you fail to appear because the president has told you not to appear as you're required to or to produce documents, we're going to consider that as evidence of obstruction of Congress and use that as an adverse inference. And that was a separate article of impeachment against President Nixon. We're not going to allow the administration to obstruct this process and benefit by engaging us in protracted litigation that could take months and months. We've put them on notice. If they have something that is exculpatory to the president, he ought to let them come forward. But I think we can draw an adverse inference by his direction to them not to appear.
Yeah, it's certainly incriminating if he won't allow the people, if the people that were the closest to him in this whole situation had information that was exculpatory, you'd think he'd be rushing them to Congress to give that information, but instead he's withholding it. Neil Katyal in the New York Times wrote about this obstruction and the way that they've behaved toward this inquiry. While the Ukraine allegations have rightly captured the attention of Congress and much of the public, Mr. Trump's effort to hinder the House investigation of him is at least as great a threat to the rule of law. It strikes at the heart of American democracy and is itself the essence of an impeachable offense. I mean, what we have here is sort of the Andrew Johnson case for impeaching, meaning that Congress appropriated money and Trump said, I'm not giving it to you unless you do me a favor. And you've got the Nixon case for impeachment, which is obstructing the investigation itself. So it feels like there's so much already on the table. In your mind, as somebody who's on judiciary, do you think that the Congress will be in very short order ready to go ahead and write articles?
Well, I think there's no question that and I have had the opportunity to sit through the depositions as a member of the Foreign Affairs Committee. I think the American people will see over the next several days and next several weeks overwhelming evidence of the president's wrongdoing, that he abused the power of his office, that he undermined our national security. He undermined the integrity of our elections by withholding military aid in a White House meeting until he got the Ukrainians to gin up a phony investigation against his chief political rival. This is damning and shocking conduct on the part of the president. Obviously, we have proceedings in the Judiciary Committee. We've approved proceedings that will give the president a chance to come forward and present evidence and cross-examine witnesses and try to explain this. But I think there is overwhelming evidence of wrongdoing, certainly sufficient for us to move forward before the Judiciary Committee and consider articles of impeachment. And I expect that will happen, that we'll have the responsibility to consider that in short order. And the president will have an opportunity to respond to it. And then if we do file articles of impeachment, the House will have the opportunity to take them up. But the evidence is overwhelming. The facts are really uncontested. And we've heard a number of different defenses from Republicans, but none of them have challenged the actual facts that have been alleged.
Right. And Joyce Vance, I think what a lot of people don't understand, if you get a jury summons, you have to show up. When you get ordered by a court to do something, you have to do it. How can it be permissible for these witnesses to simply say, I'm not showing up? I think a lot of people are confused as to how they can get away with that and not wind up in jail.
So I think the short answer is that it's not permissible. And if we had a criminal justice system that was functioning the way that it should be and does under other administrations, there would be accountability. But unfortunately for Congress, it doesn't have the ability, or at least it doesn't have an easy path forward to directly enforce its subpoenas. Its real enforcement mechanism is to ask the U.S. Attorney in the District of Columbia to enforce a subpoena on its behalf. And of course, given this administration and this Attorney General, that's not an easy path forward. So I think Congress has taken a really smart approach here, which is that they're calling the witnesses, and they've put the witnesses on notice that their failure to appear, whether it's pursuant to a subpoena or a lawful request for someone in government to show up for what's essentially an oversight hearing, that those failures are acts of obstruction that can ultimately be charged by Congress against this president in articles of impeachment. That's where the accountability comes in. It's slow, it's frustrating, but we're moving the right direction now.
And you know, Neera, Donald Trump today, of course, is out attacking Ambassador Taylor and George Kent. And you laugh, but I mean, the thing is that if that is what people fear, if those who are not cooperating, if that's the worst that you're going to get, is that Donald Trump is going to tweet nasty things at you, it does confuse me as to why people are so afraid to follow the law.
Well, I think we're actually seeing more and more of career officials speaking out. So I think the fact that we now have a career official in the OMB, the Office of Management and Budget offices are within the executive complex, so it's much closer to the White House. The fact that we have a career official who's planning to testify and defy the White House is, I think, an important fact. And that career official is going to give us lots of information, and we'll tie this much more closely. Remember, Mick Mulvaney was the former director of the OMB. He is the chief of staff. It's very likely he communicated directly to Russell Voigt and to possibly career OMB officials like Mark Sandy. And so I think we're seeing many more people coming out. It is interesting that we have two other career officials who are within the embassy of Ukraine who are now speaking out about overhearing this conversation between Gordon Sondland. And I think the really most important part that we see is that House Democrats are very smartly, in my view, making the case about the crime here. There is absolutely an abuse of power, but the abuse of power has a definition, and it is bribery. And I think most importantly for the American people, they saw a clear case yesterday, the evidence being laid out, and now they're understanding what it is, a crime. And if this crime is not impeachable and punishable, nothing really is. As you said, it's laid out in the Constitution. So I think this is a very important step that the Speaker has taken by defining it. And I think what will be really important is tomorrow you're going to see some of the victims of this crime, an ambassador who was smeared in order to move her out because she was trying to do the right thing for the country. She was victimized for being a patriot.
Yeah, and I think that now that it is very specific, Congressman, do you have a sense, just being on judiciary, of what the timeline looks like for how long you think this process is going to go?
You know, I think we should expect a couple of weeks, maybe another week at least, of hearings before the Intelligence Committee. I think the Intelligence Committee, shortly after that, will conclude its work, hopefully prepare a final report and a referral to the Judiciary Committee, which the resolution we passed authorizes. I think there are a number of other committees who have been engaged in oversight who will similarly make a referral for any appropriate consideration by judiciary. And then my hope is that shortly after that, the Judiciary Committee will meet and consider whether or not articles of impeachment ought to be prepared and filed with the full House.
And very quickly before I let you go, Congressman Peter Welch, your fellow congressman, has said that based on what he's heard right now, he'd be comfortable voting articles of impeachment against Donald Trump based on what he's heard so far. Do you agree?
Well, I think, as I've said, I think there's prima facie evidence of a crime and of serious wrongdoing. I think we owe it to the president during the judiciary hearings, as the rules provide, to give him an opportunity to present evidence, to have his lawyers cross-examined, to see if he can explain what seems very obviously serious misconduct. So I think we ought to go through that process. But this is very serious, and I think the Judiciary Committee will have ample information to move forward if the committee members consider it appropriate.
Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.